prosecutors who don't understand their duties when it comes to turning over stuff that we've requested in a criminal case. This is one of my pet peeves. It drives me bonkers. Um, up until a few years ago, we weren't entitled to much in a criminal case. In other words, when we wanted to see reports or evidence, get information about the charges against our clients and the things that would help us do a better job and prepare for trial, we just weren't entitled to it, and that shocked a lot of people. And honestly, when I was a prosecutor, I didn't actually like the rule. I thought the way that it was set up was kind of screwed up. I mean, considering that when somebody is charged with a crime, they're supposed to be, innocent unless proven guilty. And yet here we had these really draconian rules when it came to criminal discovery that made it actually pretty hard to defend them in a lot of situations. Anyway, fast forward from my days as a prosecutor, and a few years ago, at the beginning of 2014, the law changed. And up until that point, pretty much the only things that prosecutors had a duty to turn over to us were things that were called exculpatory, or Brady is the legal term for it because of a certain Supreme Court case. And pretty much the standard was so high, though, that it was in most situations hard to prove that something was exculpatory. In other words, if the prosecution didn't turn it over and we wanted to complain about it, first of all, we couldn't really complain about it until after our client was convicted, maybe sitting in prison. And then we actually also had to show that evidence or information would have made the difference in the criminal case. And that's a pretty high standard to meet, because sometimes that piece of information itself may not have been so huge, but it might have led to other information in our investigation, or it might have led to a reduced sentence. Or anyway, coming back to present day, beginning of 2014, the law changed because of a case called, defendant called Michael Morton, who'd been wrongfully convicted and spent 25 years in prison for a crime he didn't commit. And what the Texas legislature did is basically opened up a huge category of information that the defense is entitled to obtain just by asking for it, right? So in addition to all the things that the prosecution has always had a duty to turn over, of course, whether or not they actually do that is another question, but that's a whole nother subject. But they, prior to this law change, they weren't required to turn over a whole bunch of other stuff the defense, any good defense attorney is going to want, and because it's going to be, help us do a good job of defending our clients at trial. So pretty much once that law was changed, at least legally, we were suddenly entitled to obtain really anything that we wanted in the case. At least anything that would help us, and that's, what else would I want? So anyway, bottom line is that, in the first few years after the Morton Act was passed, it was really hard to educate prosecutors, to, help them understand, prosecutors and judges. And honestly, many of my own colleagues, other criminal defense attorneys, didn't really seem to understand, the changes that statute had made. In the last few years, it seems like it's gotten better. But I will admit that the last couple of years, I hadn't been the attorney usually with my firm, having these conversations with prosecutors. So, my team primarily was doing that, and we would staff the cases and discuss challenges and so forth, but they're not necessarily going to complain about every little irritating thing that a prosecutor might say or do when we're staffing our cases. And so now I've been spending more time in the last couple of months. I've been spending more time in that role, having these conversations with prosecutors myself. And this morning I was just aghast, because I did have a conversation with a prosecutor where his response is like, he's objecting to some of my requests for discovery, and his responses, or his objections rather, are along the lines of like the way the law used to be, right? Like, they don't have to turn this over because it's not exculpatory, it's not Brady, and things like that. And I'm just like, what planet do you come from? Because it's been 7 years since that statute was passed, and there's all of this stuff that you have to turn over that's way beyond just what's exculpatory for my client. Anyway, it just really drives me crazy. And I don't understand why someone wouldn't be more familiar. I mean, this is a felony level prosecutor. And apparently he staffed, at least according to what he said, he staffed it with his supervisor, the director of the branch. I'm not going to get into more details, but the division within the DA's office that he works with. And so he's not alone in his, what I would say is, very ignorant opinion about what he's required to turn over. So, the interesting thing is there's a decent chance we won't even get to that. In other words, we may reach a settlement agreement that is favorable to my client without having to litigate that issue, which is good. I mean, that'll be better for my client, better for me, certainly better for the court, save everyone a lot of time, but in some ways, sometimes, I'm kind of sitting here going, in a way, that's kind of too bad, because there's a decent chance that this ignorant perspective will also survive the case. And I was just, astonished and a little outraged that I could be hearing from a felony prosecutor in Travis County today, this week, the things that his opinions about what's discoverable in a criminal case, because I absolutely know that he's wrong, and also know, how much effort it will take if we have to fight that fight again. And I'm like, why am I still having to fight this fight in 2021? This law went into effect in 2014. So, it is what it is, but I just wanted to vent. So thanks for listening. Y'all take care. Bye now.